Hello viewers, Attorney Buado here. Welcome to the Criminal Law Jurist. Today we talk about the last two limitations on the power of Congress to enact penal laws. This is Episode 3, Ex Post Facto Law and Bill of Attainder. Let us first define what is a penal law. What are its elements, and why this is important to the said limitations. So what is a penal law? It is an act of the legislature defining certain acts or omissions, prohibiting their commission, and imposing penalties for their violations. Those that define crimes treat of their nature and provide for their punishment. It has three elements. First, the law must define the criminal act. Second, it must prescribe a penalty. And third, it must be an act of the legislature. Why is it important to know whether a statute is penal? Because only then will the rules of in dubio pro reo and ex post facto prohibition will apply. What is in dubio pro reo? It is a doctrine that means that all doubts are ruled in favor of the accused. What are the two areas of doubt? First, in the law itself. The law may be ambiguous. For example, before its amendment, many provisions of the revised penal code missed the age of 9. Like the old Article 12 on exemption from criminal liability. In paragraph 2 of Article 12, it exempts a person under 9 years of age. Paragraph 3 exempts a person over 9 years of age and under 15 unless he acted with discernment. So if the offender is exactly 9 years old, will he not be exempt? He will be, because in dubio pro reo to the rescue. The doubt is concluded in favor of the 9-year-old. Second, in the evidence against the accused. If the evidence between the defense and the prosecution are equal, then the accused will be acquitted because of in dubio pro reo. Related to this is the equipoise rule, which will be discussed in other episodes. So, if the law is procedural in nature, like suspension pending litigation, extradition treaty, and substantive laws on jurisdiction, those matters are not covered by the rules of in dubio pro reo. Therefore, this in dubio pro reo, you must remember those Latin terms, is the most fundamental principle. So if the law is not penal in nature, in dubio pro reo will not apply. Let's go to ex post facto prohibition. Again, if the law is not penal in nature, ex post facto will not apply. So what is an ex post facto law? Simply, an ex post facto law is a penal law that is retroactive in application. It is prohibited in relation to the prospectivity characteristic of penal law. The characteristics of ex post facto law are: first, it is a penal law. Second, it is retroactive in application. And third, it is prejudicial to the accused. That means if it is beneficial, it is not prohibited to apply retroactively. This is related to the prospectivity characteristic of penal law. The retroactivity of penal law is of two modes. First, the law will expressly say that it shall apply to acts prior to the date of the law. The second mode is, the law is okay, it is not retroactive in application, but the court applies it retroactively. So, those two kinds of application are prohibited. The retroactivity must be prejudicial because only then will ex post facto prohibition apply. If a penal law is beneficial, it must be applied retroactively because Article 2 says that even if the accused has been convicted or serving final sentence, he will still benefit from a beneficial law. Article 22 specifically says, penal law shall have a retroactive effect insofar as they favor the person guilty of a felony, although at the time of the publication of such laws, a final sentence has been pronounced and the convict is serving the same. So here are some examples of ex post facto law. One that makes an act which was innocent before the passing of the law criminal, or aggravates or makes the crime greater than it was when committed, or changes the punishment and inflicts a greater punishment than what the law prescribed when it was committed. Another, alters the legal rules of evidence and receives less or different testimony than what the law required at the time of the commission of the offense in order to convict the defendant. Deprives an accused of protection to which he has become entitled, such as the protection of a former conviction or acquittal or a proclamation of amnesty. And lastly, assumes to regulate civil rights and remedies only, but in effect imposes a penalty or deprivation of a right which when done was lawful. So what actual cases do we have applying this ex post facto prohibition? In Wright versus Court of Appeals, the petitioner is objecting to his extradition because he believes that it is ex post facto. The extradition treaty was executed after he has committed the charge against him. So the Supreme Court said extradition treaty is not a penal law. Ex post facto does not apply. Another example, Republic Act 8249 is the Sandigan Bayan Law. It is a procedural law, not criminal law. And therefore, ex post facto rule does not apply. Now let's go to Bill of Attainder. What is the Bill of Attainder? It is a law which inflicts punishment without trial, and the essence of which is the substitution of the legislative will for a determination of guilt. Why is it prohibited? Because it violates the due process clause of the Constitution, which requires notice and hearing before a court of competent jurisdiction. Also, It violates the principle of separation of power among the legislature, executive, and judiciary because the legislature is encroaching upon the right of the court to determine guilt. Do we have actual cases on Bill of Attainder? Yes, we have. In one case, the offender is contending that BP22 is a Bill of Attainder. But the Supreme Court said, no, for every element of the crime is still to be proven before the trial court to warrant a conviction. Another, the anti-subversion law, is not a Bill of Attainder because were it so, then the communists will not have to be charged in court as the law alone would be sufficient to secure their punishment. By the way, the Anti-Subversion Act has been repealed. So there you have the 5 limitations on the power of Congress to enact penal laws. In the next 2 episodes, we will discuss the characteristics and philosophies of criminal law. We will understand why some crimes are punished more severely. So, we are now going deeper into Criminal Law 101. See you then!